On Tuesday, arguments in former President Donald Trump's appeal of E. Jean Carroll's defamation lawsuit were heard by the District of Columbia Court of Appeals. Although the case involves an alleged rape, the question at hand is whether presidents can be sued for comments they make while in office. The case involves the rape claim that E. Jean Carroll, a longtime columnist for Elle, made against Donald Trump and his subsequent denials. Carroll claimed in an essay she wrote for New York Magazine in June 2019 that Trump forced himself on her in a Bergdorf Goodman dressing room in the middle of the 1990s. When Carroll made the rape claim public, Trump was president. In a series of statements to the media, he categorically denied her claim, praising her appearance and claiming that she made the claim up to sell her memoir. Trump went so far as to say that he had never met Carroll, but an image of the two talking at a party in 1987 quickly proved him wrong. In November 2019, Carroll filed a defamation lawsuit against Trump, claiming that her career suffered as a direct result of Trump's defamatory statements. Trump and the Department of Justice, which later intervened in the case, have argued that a federal law known as the Westfall Act provides protection for him. As a result of the Westfall Act, employees of the government are shielded from legal action when they carry out their duties. The act is frequently used to keep employees of the United States Postal Service from being sued for car accidents they cause. Instead, in such lawsuits, the U.S. government is named as the defendant. However, the courts have yet to agree on whether Trump is covered by the Westfall Act in this case. In October 2020, U.S. District Judge Lewis Kaplan ruled that it did not, stating that it was evident that when he denied Carroll's rape allegation, he was not acting in his official capacity. The allegations have no connection to the official business of the United States, and his comments concerned an alleged sexual assault that took place several decades before he took office, Kaplan wrote. However, a three-judge panel decided 2-1 in favor of Trump when Trump's lawyers appealed Kaplan's decision to the U.S. Court of Appeals for the Second Circuit. However, the panel requested the D.C. Court of Appeals to weigh in on the question of whether Trump's remarks were made within the scope of his employment and agreed that there was some uncertainty about this. Arguments were heard in that court on Tuesday. The main question in the case is whether Trump made the remarks about Carroll while he was president. At the outset of his argument, DOJ attorney Mark Freeman stated that Trump's remarks regarding Carroll were plainly inappropriate. A senior elected official is to be responsive to the public and the media on matters of public concern and major public controversies, and that when they do so they generally act within the scope of their office or employment, Freeman stated. Trump's attorney, Alina Habba, reiterated this argument. She claimed that during a briefing that took place on the lawn of the White House, Trump made some remarks about Carroll in response to questions from the media. She stated that a ruling in Carroll's favor would hinder a president's ability to perform their duties. Presidents shouldn't be afraid to respond to questions from the front lawn podium, Habba stated. One of Carroll's lawyers, Joshua Matz, argued that Trump's remarks about Carroll were made for personal reasons and were not related to his job. Matz went on to say that Trump might have hurt himself by insulting Carroll. According to Trump, he would have a much stronger case that he was carrying out his duties as president if he had simply denied the allegation. Carroll probably won't be significantly affected by the appeals court's decision because she filed a second lawsuit against Trump in November. She also alleges rape in that lawsuit, which also includes a defamation claim against Trump for calling her claims a hoax and a lie on his Truth social media platform in October 2022. He can't claim Westfall Act protection because he said those things after leaving the White House. A charge of battery is also made in the second lawsuit. Carroll had previously been unable to sue Trump for the alleged rape itself due to the expiration of the statute of limitations. However, the Adult Survivors Act, a brand new law passed in New York, temporarily makes it possible to sue for sexual assault after the statute of limitations has run out. If Trump does not settle the case first, this indicates that Carroll's allegations against Trump are likely to be presented to a jury in one way or another. However, the case remains significant in determining how much protection the Westfall Act provides a sitting